My name is Shivani Singh, and I'll be your instructor for the next few hours in our session on how to read a patent and its importance in the world of innovation. This course is designed for everyone interested in innovation, research, and development, including students, entrepreneurs, researchers, and anyone involved in intellectual property. Whether you are an investor looking to invest in an idea, a researcher seeking inspiration for new projects, or simply curious about the world of patents, this module covers information for everyone. The concept of patent is not new and has emerged centuries ago. The first case of intellectual property protection was for the newfangled loaf of bread, which dates back to 600 BC, giving chefs the option to keep the recipe for a unique dish to themselves and enjoy the profits alone. Some historians say the earliest industrial patent application was made in 1421. It was credited to Filippo, a Florentine architect who created a crane system for shipping and moving marbles from Carrara highlands. The Venetian Senate established the first patent law in 1474, identifying intellectual property and the significance of safeguarding inventors' right. A patent is a legal document that gives the innovator exclusive rights to make, use, and sell their invention for a certain period. This means no one else can use or sell the invention without the innovator's permission. Patent can cover various innovations from simple mechanic devices to complex computer algorithms. But why are patents so important? For several reasons, patents are important because they encourage innovation by providing inventors with a way to protect their ideas and profit from their hard work. This in turn encourages more people to invest time and resources into developing new ideas and products. Patents promote economic growth by creating jobs, increasing productivity, and allowing innovators to profit from their ideas. They are more likely to invest in their businesses and hire more workers. This in turn leads to economic growth and prosperity. Lastly, patents help to protect consumers by ensuring that the products they purchase are safe and of high quality. When an innovator has a patent, they are more likely to invest time and resource into testing and refining their products, ultimately leading to a better product for consumers. Let's understand some exciting examples of patents. One of the most famous patents is the telephone, patented by Alexander Graham Bell in 1876. This invention revolutionized communication and paved the way for many other innovations, including the cell phone and the internet. Another interesting patent is the post-it note, invented by Spencer Silver in 1968. Silver was trying to develop a strong adhesive, but instead he created a weak adhesive that could be easily removed and repositioned multiple times. This invention became one of the most popular office supplies in the world. Let's understand why learning to read a patent document is essential. Let's understand why learning to read a patent document is essential. Patent documents are essential sources of information for individuals involved in innovation and research. Reading and interpreting patent documents can provide valuable insights into the state of the art, new technologies, and potential business opportunities. By understanding how to read patent documents, students and entrepreneurs can make informed decisions about research and development, avoid infringement of existing patents, and identify potential licensing opportunities. Additionally, familiarity with patent documents is vital for anyone involved in intellectual property law, technology transfer, and the commercialization of innovations. To understand the importance of getting your innovation patented, let's learn the skills to read a patent along with understanding the drawbacks of not knowing how to read the patent document. Understanding the drawbacks of not knowing how to read the patent document. Number 1. Missed opportunities. If you don't know how to read a patent, you might miss out on valuable information that could help you develop your business or research. Patents often contain information about new products, technologies, and processes that could benefit your work. Number 2, infringement risks. If you are unfamiliar with your industry's patents, you might unknowingly infringe on someone else's intellectual property. This can result in expensive legal battles and can damage your reputation. Number 3, reduced ability to protect their inventions. Not being able to read a patent can also make it more challenging to protect your inventions through the patent system. Without understanding what is already patented, you will not be able to draft a robust patent application that can withstand legal challenges. Number 4, wasted time and resources. Without the ability to read a patent, you might spend time and resources developing a product or process already patented by someone else. This can be frustrating and waste valuable time and resources that could be used more effectively. Number 5, missed collaborations. Patents can also be valuable tool for networking and collaboration. If you are unfamiliar with the patent in a field, you might miss out on opportunities to collaborate with other researchers and entrepreneurs working on similar projects. Number 6, limited innovation. Not understanding patents can limit your ability to innovate. Patents can provide valuable insights into your field state of art and help you identify areas where innovation is needed. Without this knowledge, you might miss opportunities to develop new and innovative products and processes. Number 7, lack of understanding of the competitive landscape. Patents can provide valuable information about the competitive landscape, including what products or technologies are being developed and where the market is headed. Without being able to read patents, you may not completely understand the industry, which can impact decision making and business strategies. Patent documents are an essential source of information for anyone involved in innovation, research, and development. However, reading a patent document can be challenging, especially for individuals without a legal background. This course aims to provide a comprehensive guide to help students, entrepreneurs, and anyone interested in innovation learn how to read patent documents effectively. This module will help you understand the structure and components of a patent document, identify the critical elements of a patent document, including claims, specification, and drawings, interpret the technical language and legal jargons used in patent documents, learn how to search and navigate patent database to find relevant information, evaluate the strength and scope of a patent. By the end of this module, you will have a thorough understanding of how to read and analyze patent documents and a deeper appreciation for the importance of patents for entrepreneurs, inventors, and innovators. This knowledge can be applied to various fields from software development to genetic engineering. It can help you make informed decisions about patenting strategies and intellectual property protection. Before we get into the technicalities of reading a patent, let's take a quick look at the 4 very important forms that need to be filed while applying for the grant of a patent in India. It becomes very important to identify and read these forms as you will get most of your information for Indian patents from these forms. Let's understand important forms. Form 1, Application for Grant of Patent. The form is the primary application form that initiates the process of seeking a patent in India. It collects important information about the inventions and the applications. The form includes the following details. Title of invention. This is concise title that describes the essence of an invention. Name and address of applicants. The form requires the full name, address, and nationality of applicants asking the patent. Field of invention. The applicant needs to specify the technical field to which the invention pertains, such as electronics, pharmaceuticals, or mechanical engineering. Priority claim. If the applicant has filed a corresponding application in a foreign country before filing in India, they can claim priority based on that application. This section of the form captures the details of the priority claim, including the filing date and country. Type of patent application. The applicant needs to choose whether they are filing a provisional or complete application. A provisional application provides a placeholder and establishes an early filing date, while a complete application includes a detailed description, claims, and drawings. Name of inventors. This form requires the name of all inventors involved in the invention. Form 2. Provisional and complete specification. This form is used to submit the specification of the invention, which can be either provisional or complete. Provisional specification. A provisional specification provides a basic and preliminary description of the invention. It outlines the nature of the invention and the technical aspects. It serves as a temporary document to secure an early filing date and allows the innovators to continue developing the invention while preserving their priority rights. A complete specification must be filed within 12 months of filing the provisional specification. Complete specification. A complete specification is a comprehensive document that fully describes the invention. It includes a detailed description of the invention, claims that define the scope of protection sought, and any necessary drawings or diagrams. The complete specification provides all the necessary information for the understanding and evaluation of the invention. Form 3. Statement and undertaking under Section 8. Section 8 of the Indian Patent Act 1970 requires the applicant to disclose any corresponding foreign application filed for same invention. Form 3 is used to provide a statement and undertaking regarding these details. Particulars of corresponding applications. The form requires the applicant to provide information about any foreign application filed in any country outside India for the same invention. This includes details such as application number, filing date, and country. Status of corresponding application. The applicant needs to specify the current status of the foreign applications, whether they have been granted, abandoned, or are still pending. Amendments made to corresponding application. If any amendment or modification have been made to the foreign application, the applicant must disclose these changes. Form 5. Declaration as to inventorship. This form is used to declare the true and first inventor of the invention, names and addresses of inventors. The form requires the full name, addresses, and nationalities of each inventor involved in the creation of the invention. These forms collectively provide crucial information about the invention, the innovators, any foreign applications, and the nature of the patent application being filed. They are integral of the patent application process in India and ensure transparency and compliance with the relevant laws and regulations. Now, we will be covering different aspects of the patent document. One is how to read a patent document, which is how to understand different parts of the document. In short, what we call patent anatomy, that would help you understand PCT documents. Patent data is incredibly important for conducting research and assessing technical information worldwide. Did you know that around 70 to 80% of available technical information is published in patents? That's why it's crucial to know how to assess and understand patent documents in different databases. A patent document contains two types of data: bibliographic data and technical data. Let's explore what each of these entails. Bibliographic data. Bibliographic data is basic information about the patent application. It includes details like dates, names of the inventor, and the applicant. This data helps us understand the type of document, its status, and when the patent application was filed. It also tells us if the applicant is seeking priority based on an earlier application. We can find out when the patent was published and where it was filed internationally. Additionally, we learn about the inventors and assignees and even get insights into patent office prosecution of the application. The examiner's citations, which are references to other relevant documents, are also mentioned. The cover page. The cover page of a patent is an important page for conducting searches. It provides information about the abstract and classification system. The abstract gives a summary of invention and the classification system that categorizes the invention into specific areas. Now, let's move on to the technical data section of the patent. Technical data starts with the title of the invention, which is usually a concise phrase describing what it is. It also tells us the field to which the invention belongs, giving us a broader idea of the application. Background of the invention. The background of the invention is a crucial part. It helps researchers understand the relevance of prior art, which refers to previously existing solutions or ideas. This section tells us about the problems addressed by the prior art and how the invention is different from what already exists. Sometimes this information is presented by referring to patents or non-patent literature. By understanding these components of a patent document, you will be able to extract valuable information from it. This knowledge will empower you as a student, researcher, academician, or entrepreneur to access technical information and make informed decisions in your field. Summary of the invention. The summary of the invention provides a concise overview of the essential features of the invention. It acts as a mirror image of the claims of the patent. Think of it as a snapshot that captures the main aspect of the invention. Description of the invention. The description of the invention consists of two parts: drawings and embodiments. Drawings. In certain fields like mechanical and electrical inventions, drawings play a vital role. In fact, filing at least one drawing is often required to secure a filing date for mechanical inventions. Drawings help visualize different aspects of the invention, such as structure or design. They are referred to in the description and must be consistent with it. Embodiment. The embodiment showcases how the invention works. Regardless of how well the claims are written, the embodiment provides practical demonstration or enablement of the invention. It's important to ensure that the embodiment aligns with the claims and clearly illustrate the working of the invention. Different types of inventions. Inventions are categorized into two types based on the fields that they belong to: predictable arts and unpredictable arts. Predictable arts. This category includes mechanical and electrical inventions, where the invention can be easily envisioned and described in an illustrative manner. Unpredictable arts. In fields like pharmaceuticals and biotechnology, inventions are more complex and often require multiple factors for successful implementations. Description in these fields must adhere to specific guidelines outlined by the patent offices. Claims. Claims are a crucial part of a patent document and are usually placed at the end. They define the boundaries of the patent rights granted to the inventor. Claims are carefully worded to precisely outline what the inventor is seeking protection. They are essential for searching and understanding patents for various purposes. By understanding the summary of the invention, the description, and the importance of claim, you will gain valuable insights into the invention. By understanding the summary of the invention, the description, and the importance of claim, you will gain valuable insights into the invention and its legal protection. Next, we look at patent number. The patent number is a unique identification assigned by the patent office. It appears at the top right of the cover page. The number not only distinguishes the patent but also provides useful information about its origin. For example, IN represents India, CN represents China, EP represents the European Union, and the US represents United States. Additional letters called kind codes indicate the status of the patent application, such as publication, re-examination, or correction. Next, we look at who are the inventors. Knowing the people involved in the invention is important. Innovators are individuals who contribute to the invention's creation. There can be one or multiple inventors, often referred to as co-inventors or joint inventors. The applicant refers to the entity that has applied to the patent, which can be a company or an institution. An assignee is a company, institution, legal entity with the interest in the patent application. Next, we look at what? The title and abstract of a patent. The title and abstract of a patent document provides basic information about the invention. The title gives a general idea of what the invention is about, while the abstract summarizes the subject matter and claim of the invention. It highlights the innovation's components, technical advancement, and at least one operable feature. Next, we look at classification code. Patents are classified using codes to enable uniform retrieval of information. Major classification systems include International Patent Classification, European Classification, United States Patent Classification, and the F1 F-term classifications used in Japan. The Cooperative Patent Classification System is also gaining popularity. When dates associated with the patent document hold importance. The filing date is when the application was submitted to the patent application. The priority date is relevant in cases involving Paris Convention or PCT, as it preserves the novelty of the invention. The publication date marks when the patent becomes publicly available and provisional rights can be enforced. The granted date indicates when the patent was officially granted. The term of a patent is typically calculated from the filing date, usually lasting 20 years. By familiarizing yourself with these aspects of a patent document, you will be better equipped to navigate and comprehend the information presented. The other aspect that we will be looking at in the course is how patents are actually identified in terms of their specific category and what is called the INID codes. The first we will be looking at patent family. Patent family data refers to a collection of related patents that are connected by common priority application. It includes patents that have been filed in different jurisdictions based on same or similar invention. Patent family data provides information about the strategy and scope of patent filings, including divisional applications and patents of addition. Patent families can be explored using databases that link related patents on their priority applications. These databases allow users to retrieve information about other patents that are connected to the specific patent. This helps in understanding the broader context and economic implications of a particular patent. Lastly, we'll be looking at internationally agreed numbers for the identification of data, also called INID codes. INID codes are important for patent searches as they can be used to find specific information within a patent document. By searching for a particular INID code, such as the code for titles, a searcher can retrieve all the titles filed within a specific time frame. The uniformly worldwide patent number is represented by the INID code 11. Similarly, INID code 51 is used internationally to represent international classification of a patent. The abstract of a patent is represented by the INID code 57. INID codes provide a way to understand and identify different aspects of a patent document. Different patent offices may have slight variations in the presentation of a patent data, but they generally follow a uniform pattern. It is important for searchers to familiarize themselves with these variations when conducting searches or analyzing patent documents. Descriptions of an invention are crucial for understanding the scope, technical details, and working of a patent. The description provides information about the field of invention, the background, and the purpose, and the objective of the invention. It may also include experimental details and other research information related to the invention. Understanding the description of an invention is essential for the patent searches to evaluate its relevance and potential improvements. The description helps researchers grasp the features and workings of the invention and can inspire new ideas for further development. Overall, patent data, INID codes, and the description of the invention are important aspects of patent documents that aid in the analysis, retrieval, and understanding of patent information.